our resistance to the hearings consisted of trying to coach people as to how you can stand up to this Canwell and stay out of jail, because they used their state power to prosecute people for refusing to testify as they desired and name the names of their friends and relatives and state whether they were or weren't communists. I mentioned earlier that this was the first hearing in which the Fifth Amendment was used, to my knowledge. My then law partner, Barry Hatton, was the person who ingeniously decided that in the case of Joe Butterworth, he should raise the fact that he shouldn't be required to testify against himself as one of the reasons that he wasn't going to cooperate with the committee. Joe Butterworth was a professor of English at the University of Washington, a job from which he was shortly thereafter severed by the university tenure hearings. In any event, Barry suggested that he just insert, when he refused to name names, that he didn't think he should be required to testify against himself, and he did. As a consequence, this of course was not at the pension union hearing, but at the second hearing, the university hearing, as a consequence of which he was one person who was not prosecuted as a result of his failure to testify. Going now to the second hearing, which was a follow-up on the pension union hearing. To the best of my recollection, nobody was directly prosecuted for refusal to testify as a result of the pension union hearings. This was just an exposure type thing. And it wasn't until they came to the university professors that they invoked the state power to charge people with refusing to testify before a legislative committee, and prosecuted 2 university professors and 3 Playhouse, 2 or 3 university professors and 3 people from the Seattle Repertory Playhouse who actually had no connection with the university.